So thanks again for joining us, everyone, today. So my name's Josh Clark. I'm the Business Support Coordinator at the University of Essex Enterprise Zone. And today I'm joined by my colleague, John, who is the Business Support Manager at the University of Essex Enterprise Zone. And you'll see with us today, we have the qLegal's team made up of Mara, Mariam, Hamda. Bunmi is having a bit of a connection issue, so she may join us part way through, and we've got Eliza as well. So today's session is all around getting your corporate structure and your related legal documents in order. So qLegal are a arm of Queen Mary University, who focus all around supporting early stage businesses with their legal processes and legal documents. I'll let the team give you a little bit more around that and how you can benefit from this legal expertise yourself with your own business.
So hello, everyone. Welcome to today's workshop on getting your corporate structure and related legal documents in order. I just want to say thank you to our workshop host, Josh, for organizing this. So we hope you will find our workshop beneficial and get a clear idea of corporate structures and how to form them. So just a little introduction about us. So my name is Marah, and presenting with me today are Bunmi, Mariam, and Hamda. We all attend Queen Mary University of London and are completing our Masters in Law. We're all part of the qLegal family, who we are representing today. qLegal is a pro bono commercial law services provider within the Center for Commercial Law Studies at Queen Mary. They offer free legal advice as well as education to a variety of individuals. And the legal areas qLegal can advise you on include intellectual property matters relating to copyright, trademarks, and patents, data protection and GDPR compliance, types of business structures and business incorporation, which is what our workshop today is about, as well as commercial agreements. Within qLegal, there are 4 programs that students partake in and are supervised by qualified solicitors. So the first is the legal advisory, which comprises one-to-one written legal advice. The second is the public legal education, which is what our team and this workshop are a part of. So we deliver workshops to educate client groups on legal and business matters. And there are also the externships and consultancy projects in which the students work for specific businesses. I just want to make clear at this point that this presentation does not constitute legal advice. So as mentioned, qLegal does have a one-on-one legal advice clinic, which you can apply for if you have any specific legal questions. The aim of this workshop is to describe the law in general terms and educate rather than provide advice on specific situations. And I have put the link to the qLegal's legal advice clinic on the final slide of the presentation so that you can find more information and apply to the legal advice clinic if you would like, if you have any questions. This is just an overview of what we will be covering today. We will start off with addressing why choosing the right corporate structure is important, what is a corporate structure, and what factors to take into account when choosing a structure. Bunmi will then be talking about the different types of structures you may be interested in and their individual aspects. Mariam will then provide you with the advantages and disadvantages of the corporate structures. And then Hamda will end by explaining how to form the business structure of your choice, and closely tied to that is what legal documents you will need to produce. And by covering these topics, we aim to help you answer the key question, which is what corporate structure is most appropriate for my business, and how do I go about forming it? So this is a question we want you to have in the back of your mind throughout the workshop. So we're going to start off with why is choosing the right corporate structure important? So starting a business is very exciting, but brings with it a lot of challenges, one of which includes picking the right corporate structure. So what is a corporate structure? Well, corporate structure refers to the legal structure of a business. And this is not to be confused with the internal structure, which concerns the different departments in the business, such as the marketing department. When you talk about corporate structure, we mean the legal status and form of a business. And there are many different types of structures, as you will come to see. You can have a one-person business, a business operated by 2 people, a private company, and so on. So what does a corporate structure do, or what purpose does it serve? Well, amongst other things, the corporate structure indicates the rights, the obligations, and the liabilities the owners of the business may have. Importantly, it also indicates whether the business is a separate legal entity. So this concept will be referred to many times in the presentation and is very important. So I just want to explain that a little bit. So only certain structures attract a separate corporate personality, which means that the business is considered detached from the owners and the investors. Legally, the business and those behind it are separate. This in turn impacts the personal liability of the owner. When a business has a separate corporate personality, the owner has limited liability, and the owner's liability is limited to what they have invested. So whoever the business as an entity may owe money to cannot come after the personal assets of the owner. However, this is not true of all the corporate structures. Some structures do not attract this separate corporate personality. And in those cases, the owners will have unlimited liability and their personal assets may have to be sold to satisfy any outstanding debts that the business may owe. So that's why it's really important to carefully select your corporate structure, because the rights, the obligations, and the liabilities will differ from structure to structure. So now we'll discuss what are some considerations to keep in mind when picking a structure. Some important factors include the management structure, the ownership structure, liability, funding, and tax. So the management structure will influence how and by who the business decisions will be made by. So do you envision that the decision-making process to involve a wider group of people or only to be carried out solely by you? You also have to keep in mind the ownership structure that you want. So for example, if you have more than one owner, then a sole trader would not be suitable. Or if you want an ownership structure based on shares, then a partnership would not be the right structure. Well, in terms of liability, as we have discussed, where the business structure doesn't attract a separate legal personality, the owner will be personally liable for any debts that the business may have. You also have to keep in mind that the type of structure you choose also has an impact on the type and the amount of finance available. And one type of funding is through the investors who in exchange would want shares in your company. So this type of funding would not be available for all types of corporate structures, such as sole traders or partnerships. Different structures are also subject to different types and levels of tax. So these are just some considerations to keep in mind, which will be elaborated on during the presentation. And now I'll pass back to Banmi to discuss the different structures and the ones that you may be interested in. Thank you.
Right, so we have different types of corporate structures, and they can either be incorporated or unincorporated. The major distinction between these two categories is that the incorporated entities have a separate and distinct legal personality, unlike the unincorporated forms. The examples of the structures available include, we have sole traders, we have the partnerships, limited liability partnerships, private companies limited by shares or guarantee, and community interest companies. So the pie chart on the screen shows the popularity of the different corporate structures in the UK private sector. At the start of 2021, there were 3.2 million sole proprietorships, 2 million companies, and also 384,000 ordinary partnerships. As you can see, the most popular are sole traders, amounting to 57% of the total businesses in the UK private sector. As you all are entrepreneurs and startups, we will focus our presentation on three major corporate structures that will be most suitable for you, which are the sole traders, limited liability partnerships, and private company limited by shares. Sole traders, we'll start with that one. As the name suggests, a sole trader is an individual who offers goods or services to others in return for payment. This can also be interpreted as someone that is self-employed or an independent contractor, like a plumber, for example, or an electrician, or someone that just works alone. As a sole trader, there is no separation between your identity and that of the business you have registered. You will, at every point in time, be personally liable and responsible for any losses the business makes. And at the same time, you will be the sole beneficiary of all the profits. You will also be required to file your taxes as and when applicable. Next up, partnerships. A partnership is one or more persons coming together for a common business purpose. In a general sense, this is very similar to registering a sole trader. You and your partners will share the responsibility for the business. Each partner is also individually liable for the debts of the business. In both forms, we see the trend of personal liability of the members, which is the fundamental characteristic of unincorporated entities. In the limited liability partnerships, however, there's a slight distinction. The structure is different. LLPs, as they're popularly called, are corporate entities with a legal personality. So it's a sort of hybrid between a company and a partnership. Once an LLP is set up, it attains independent legal status and offers limited liability to its members. The limit of each partner's liability is agreed upfront and set out in an agreement between the partners. And so since LLPs are closer to companies in nature and structure, this structure particularly supports financing and is a viable alternative to setting up a company for certain businesses, such as law firms, accounting firms, and even dental practices. LLPs do not have shares and the partners do not have any obligation to contribute capital. So it's very important to just put that out there. It's also important to mention that for tax purposes, the LLP partners are treated like ordinary partnerships. So at which point, each partner remains liable for their own taxes and their profits from their businesses. So it becomes, it kind of defaults back to being an ordinary partnership for the purposes of taxes only, right? The next one is probably the one you're most interested in, is a private company limited by shares. Incorporated entities with separate and distinct legal personalities are known as companies. A limited liability company can either be limited by shares or limited by guarantee. Where a company is limited by shares, this means that the company has a share capital and is owned by shareholders. Who are shareholders? Simply put, that's a person or a corporation who owns shares in the company. The amount paid by the shareholders for shares held by them constitutes the capital used to run the business. Something to also bear in mind is when issuing shares, we can have different classes of shares. For example, we can actually categorize them as Class A shares, Class B shares, or Class C shares. Each category of shares provide voting rights, rates of dividend payments, and various other rights to each class of shareholder. This generally means you can give different rights to different shareholders. For example, you can give a Class A shareholder the right to vote on certain matters that a Class B investor does not have a right to vote on. So it's just generally to keep it separate. So Class B shareholders will have their own separate rights, Class A shareholders will have their different rights, and Class C shareholders will have theirs as well. The liability of shareholders to creditors of companies is limited to the amount, if any, unpaid on their shares held by such shareholders as at the time when the debt is being called upon. We see here how the personal identity of shareholder is separate and distinct from its corporate entity, unlike the previous structures we discussed. We'd also like to mention how a company is run. A company is run by its directors on behalf of its shareholders. It is possible for you to be both a director and a shareholder. The company distributes profits to its shareholders in the form of dividends after tax deductions for working capital and corporation tax. Just to add, companies limited by shares can either be private or public. The major difference between both is that the public limited company is allowed to offer its shares for sale to the public. A public limited company will usually start off as a private limited company anyway, and most likely will go public for the purposes of raising finance in an open market. And with that, I'm going to hand it over to my colleague, Mariam, to take you through interesting comparisons of the structures.
Thank you, Bunmi. Hello, everyone, and thank you again for joining us for this session. I will be now going through some advantages and disadvantages of the discussed corporate structures, and I will start off by going through sole traders and limited liability partnerships, and then I'll move on to talk about private limited companies in more detail. So starting off with sole traders, the advantages, the first point that I would like to make is that it's a very simple form of a business structure. And there is no need to register with the company's house. There are no legal filing requirements or fees. Unlike limited companies, there are fewer statutory obligations, and there is no need to complete many forms such as confirmation statements or accounting confirmation. What you will need to do, however, is to register it with HMRC, which is Her Majesty's Revenue and Customs. And you will also have to pay self-employed national insurance contributions. As there is no need to register the entity and there is no need to pay the fees to the company's house, there is less paperwork and less personal assistance required, which significantly reduces the setup costs. And the accounting process, it is also much simpler, as there is no need for formal annual accounts or corporation tax return. Moreover, as a sole trader, you have the sole decision-making power and full discretion over your business. Therefore, you will retain all of the profits that the business has made. Sole traders, they also benefit from privacy due to the lower levels of state regulation. And as was mentioned before already, there is no need for registering the company before commencing any operations. Other types of businesses, such as limited companies or limited liability partnerships, they must file registration, which leads to all of their published accounts to be available for viewing on the company's house website. So in comparison, affairs of sole traders, they can remain confidential and they will only be available to you, your accountant, and HMRC. And finally, for the advantages of sole traders, it will be easier for you to change your legal structure to a limited company in case you change your mind. And this is especially beneficial for people who are testing out a new business and they need more flexibility to explore other structures. When it comes to disadvantages, the biggest and most important one is having no separate legal personality. If you're a sole trader, there is no distinction between you and your business. So while all of the profits of the business will belong to you, so will the losses. And as a result, you will be open to unlimited liability for all of the debts of the business. It may also be difficult for you to raise your capital and expand your business, as a great amount of investors and banks, they will prefer the business to be registered due to accounting transparency. And moreover, unlike a company, sole traders, they cannot list on stock exchange. That is because by law, there can be only one owner and one owner who operates the business. And as the sole trader cannot bring on investors by issuing shares or other securities in exchange of investment. So lastly, for the sole traders, there is no flexibility to work around the taxes and reduce the payable amount. And this is because all profits or earned by sole traders, they are subject to income tax in the same financial year in which they were made. And this means that it will be impossible to leave profits in the business and let the profits be drawn as income in the next year. Now, moving on to the next slide to discuss limited liability partnerships. Thank you, Banmi. So one of the biggest advantages of an LLP is that it is a corporate body with a separate legal personality. And that means that it can own property, sue, and be sued in its own name. And this allows the members of the LLP to enjoy limited liability. And the liability of a member will be limited to the amount of capital which they agree to contribute under the members' agreement. Comparatively, sole traders, they have very minimal protection. Members of LLP, they also benefit from organizational flexibility. And this means that the operation of the partnership and distribution of profits, it is determined by a written agreement between the members. And in comparison, affairs of a limited company, it will be managed within the confines of the Companies Act 2006, which creates much more restrictions. And lastly, while LLPs do need to be registered with the Companies House, and just like limited companies, they will have most of their information publicly available on the Companies House website. They do enjoy more privacy than limited companies. That is because the members agreement, which covers issues such as profit and loss sharing, shares in capital, management responsibilities, dispute resolution, that agreement, that document, it will remain private. In terms of disadvantages, they are quite similar to those of sole traders. There is also less flexibility to work around the taxes, and profits, they cannot be retained in the same way as a limited company. All earned profits are distributed with no flexibility to hold over profit for a future tax year. And lastly, obtaining investment. It can also be difficult for LLPs, just like for sole traders. LLPs, they have no share capital structure, and therefore it is impossible to sell portions of the business to investors. And in case someone does wish to invest capital in LLP, they must be an appointed member. So many investors, they would prefer limited companies where they would not need to become a director to buy the shares. And finally, moving on to the next slide, I will go through advantages and disadvantages of the private limited company. And the big advantage is that limited companies and their owners, just like LLPs, they are separate legal entities. And the shareholders' personal possessions, they're not at risk. And in case the business runs into any financial difficulty, the company directors and shareholders, they will only be responsible for the amount of capital they have invested. Another important advantage to consider is the ability to raise finance. Limited companies allow you to sell shares to the public, and they allow anyone to invest their money. This provides a bigger chance of a high capital, and listing a stock on an exchange, it may also lead to more investments from hedge funds and other institutional traders. And this is not the case with respect to sole traders and LLPs, where raising capital through investments can be very challenging. Running your business as a limited company, it also provides for prestige and assurance, and it can be much more attractive to both debt and equity investors. And the requirement to register your company with the Companies House and having the company listed on the public register, it automatically provides a sense of transparency, order, and professionalism within the business. And this is especially beneficial for companies in their early stages that attempt to demonstrate and establish their credibility within the market, and also win over and attract investors. Flexibility is also one of the most important advantages of a private limited company. Many startups, they engage in efforts to raise their capital through rounds of external funding. And Bunmi has already mentioned it before, so I will go over it briefly. When issuing shares to investors, you can issue different classes of shares, and by doing that, you can give different rights to different shareholders. And this will be discussed between the founders and the new investors, and it will also be reported in the articles of association or shareholders agreement, or it can be in both. Shareholders, they also benefit from liquidity in limited companies, and the transferability of shares is very straightforward, and you can easily transfer the shares held by one shareholder to another. Finally, moving on to taxes, tax benefits are very important when it comes to forming a private company limited by shares, and its efficiency is one of the main reasons why it's a popular corporate structure. Just to give you an example, as a successful sole trader business, the majority of your income would be taxed as 20 to 45% under the income tax rate. Whereas if you're a private limited company, you will only have to pay 19% corporation tax on profits. which is a great advantage. You will also be able to lessen your income tax and national insurance contributions. As limited companies, they allow you to take a combination of a salary and dividends. What it means is that the company's director will be able to take the amount of their salary below the NIC's lower profit limit and then take the remainder of the income through dividends. The dividend allowance will also provide you with an annual allowance of £2,000, which is exempt from tax. And those benefits, they can save you a large sum of money, which is one of the greatest advantages of a limited company as compared to sole traders. And lastly, the directors are also able to invest pre-tax trading income and companies' pension schemes. So therefore, the director will be able to save money rather than withdrawing all of the profits and placing them in a personal pension, which will make the director end up facing greater rates of tax through both business and personal tax. There are, however, some downsides of a limited company. And one of the disadvantages is that lending environment for startups, it can be challenging. And in cases where a startup doesn't have enough bank assets to secure a loan, a personal guarantee may be required by the bank. And therefore, access to small business funding is increasingly expected to depend on signing a personal guarantee that, in effect, it would put the business owner's personal assets on the line if the business fails, even if you have set up a private company limited by shares. However, there are a number of things that you can do, such as considering a personal guarantee insurance in order to mitigate the risks. Moreover, unlike unincorporated structures, which is sole trader, you must register with the company's house. And this process can not only be complicated, but it can also require some fees. And after registering with the company's house, the directors, they will have a legal duty under the Companies Act 2006. And any statutory breaches, such as delivering misleading, false, or deceptive information, will lead to criminal liability. And due to the registration at the company's house, you will have to provide information on company accounts, records, directors, and shareholders. And all of the provided information will be published and open for access to anyone. So the level of privacy is significantly reduced. And lastly, to meet the Companies Act regulations and maintain corporate governance, the company must keep business records such as expenses and invoices. And if a director fails to meet the requirements, they will be disqualified.
Hello, everyone. My name is Hamda, and I will be discussing how to form corporate entities and the legal documents needed to form them. I will be focusing on private companies limited by shares. However, near the end, I will briefly go through the formation of sole traders and limited liability partnerships. So the first thing to consider when forming a private company limited by shares is the name. You should not pick a name that is the same or similar to existing trademarks. You should also not pick a name that is on the list of words that are deemed sensitive, offensive, and are linked to the government or local authority. Furthermore, if a name is deemed same as, you cannot use this name. This means names that the only difference between them is certain punctuation, certain special characteristics, characters, and etc. An example of this is on the screen with the Hands UK Limited example. Next is, if a name is deemed too like, you may have to change your name. If someone complains to Companies House and Companies House agrees that the name is too like, an example of this is on the screen with Easy Electrics. A useful tool to use to make sure that your name is appropriate is to put it through the company name availability checker. There are also rules surrounding how to display the name of your company. All of this detail and more will be found in our handout, so please peruse that at your convenience when we give it to you after the workshop. Next is choosing your directors and company secretary. You have to appoint a director to form a private company limited by shares. That can be yourself or another person. A company secretary, however, helps the director run the business. They are responsible for keeping records, filling paperwork with Companies House, and communication with shareholders. For a private company limited by shares, it is optional to appoint a company secretary. Next is deciding who the shareholders are. Shareholders in a private company limited by shares are the owners. The next thing is record keeping. For company records, an example of this is keeping details of directors, shareholders, and company secretaries, the results of any shareholder votes and resolutions, loans or mortgages secured against the company's assets. For accounting records, an example of this is keeping details of assets owned by the company, debts the company owes or is owed, stock the company owns at the end of the financial year. Annually, you'll have to check that Companies House has the correct information about your company. You'll have to, after the end of each financial year, prepare a full statutory annual account and a company tax return to Companies House and HMRC, respectively. The final step is registering your company. When you set up a private company limited by shares, you have to make sure that you have an office address registered. When you're registering your company to Companies House, you must choose a SIC code. This is a code that is used as a descriptor for the type of business you have. Once that is done, you'll receive a certificate of incorporation, and this confirms the legal existence of your company. You can also register for corporation tax simultaneously. In order to register your company, you will need the following documents: a memorandum of association, articles of association, a Companies House form IN01, and a shareholders agreement. First is the memorandum of association. This is a legal document that is signed by all initial shareholders at the time of registration, agreeing to form the company. If the company is registered online, then it is automatically created as part of your online registration. However, if you register by post, then you must send it in using the Memorandum of Association template. Second is the Articles of Association. For the Articles of Association, you can use model articles. In fact, most startups do use model articles, or you can make up your own and send them when you register. The articles are the rules or the constitution of the company, detailing the rules for the management and organization of the company. All shareholders of the company, including any investors, are automatically bound by the articles when they become a shareholder. The Article of Association usually contain provisions on decision-making by directors. An example is how they can hold board meetings or how directors can be appointed or removed. A provision on decision-making shareholders, and a provision on share capital. An example is whether there are different classes of shares, or whether the directors have a right to issue shares of the company, or when a shareholder is allowed to transfer their shares. Next is the form IN01. This form needs to be filled in order to register the company. The information that goes into this form includes the company name, the company type, address of the registered office, particulars of the directors and company secretary, etc. The Memorandum of Association, Articles of Association, and the Form IN01 must all be delivered to Companies House alongside with payment of the incorporation fee. Once this is done, the company is usually registered within about 24 hours. All these documents are key in registering your company with Companies House. The final legal document is the shareholders agreement. This regulates the relationship between shareholders and the company itself. The agreement sits alongside Articles of Association of the company, but unlike the articles, it is a private document, confidential to the parties to it. The agreement sets out the rights and obligations of shareholders, describes how the company is going to be run, and creates protections and ground rules for both shareholders and the company. Shareholder agreements can vary hugely, but will often contain provisions on what issues and decisions must have approval of the shareholders. This is also known as veto rights. What happens if a company is sold in its entirety or is listed on a stock exchange? How are the shares valued? This is usually an important provision for investors. What happens if the founding shareholders leave the company? This is important because the founders are usually key to the success of the company. Provisions that prevent a founding shareholder from setting up a competing business, This is known as a restrictive covenant. Provisions on share capital. This can sometimes be included in shareholder agreements or the articles of association. Now that we've gone through how to form a private limited company by shares, let's move on to sole traders and LLPs. So for sole traders, you'll need to start off choosing a name. You can trade under your name or choose something else. Names should not be the same or similar to existing trademarks. They should also not be on the list of words that are deemed sensitive, offensive, and are linked to the government or a local authority. Secondly, you will need to record your business income and expenses for the purposes of tax returns. And lastly, for registering for tax, if your VAT taxable turnover, which is the total value of everything that you sell that is not exempt from VAT, is over £85,000, then you must register with HMRC. You can register online. Simultaneously, you can appoint an accountant or an agent to submit VAT returns and liaison with HMRC on your behalf. The date you register is known as your effective date of registration. And this is the date in which you pay HMRC VAT every year. As a sole trader, you can file your self-assessment tax returns online. Next is limited liability partnerships, otherwise known as LLPs. The rules for naming an LLP are similar as those for naming a private company limited by shares. So please do refer to the slides discussing that and also peruse the handout for more detail. You must also make sure that your name ends in limited liability partnership or LLP. For the registered address for the LLP is the official address. This is where all the written communication must be sent. The registered office address must be a physical address and in the same country that your LLP is registered. You can register your LLP either electronically using a third-party software, by post, by filling out an application form, or through an agent who handles the registration for you. As part of setting up your LLP, you can make an LLP agreement. The agreement sets out how the LLP will be run. Some of the provisions it contains are how profits are shared among members, who needs to agree decisions, members' responsibilities, and lastly, how members can join or leave the LLP. Members of the LLP must carry out their duties and meet their legal responsibilities set out in the LLP agreement. Members must also register for self-assessment with HMRC. All the details concerning how to form the corporate structures spoken about here today and their corresponding legal documents will be found in the handout, which will be given to you after the workshop.
Now reach the end of our presentation. We hope you now have a clear idea of what different corporate structures exist and how they differ from each other, how to form the different structures, and what documents you'll need to fill out. And most importantly, we hope you now have an idea of which structure is most appropriate for you and your business plans. As you can see on the slide, I have also put the link for the qLegal Legal Advice Clinic, which is the one-on-one legal advice clinic if you have any specific questions about your business or your situation.
So there's for the documents that are needed for the private company limited by shares, there's the memorandum of association, the articles of association, the company's house form IN01, and a shareholders agreement. Those are the 4 documents that are necessary for the setting up of a private company limited by shares.
Thanks, Hamda, and thanks everyone for a really interesting presentation actually, and on an area I think is really important that many businesses and entrepreneurs kind of go straight to the point of they've got an idea, they want to grow it, and they want to get investment without paying attention to the importance of getting that corporate legal structure right in the first instance. So that was a really, really interesting session.
I can see a question on regulatory restrictions on company names. I stated in the presentation that the details, I briefly went through it, but the details of what the specific restrictions are for names and displaying of names will be in the handout because it's quite lengthy. So there are, and they shall be in the handout. So when that's given to you, please do check that out. And in terms of how much the fee to register at a company's house, that's a very good question. I will get back to you and it will be placed in the handout, which will be given out after the workshop. I think, Josh, you said somewhere next week when the newsletter's out.
Yeah, thanks, Hamda. So the materials following this session, we'll put that into our newsletter. So if you're not already signed up to that, do just email us at uez@essex.ac.uk, and that will be circulated in the next week or so. Eliza, I wonder if you could just come in and just summarize some of the offerings from qLegal for some of the startup businesses who might be on the call today.
Sure. Hi, everybody. This is Eliza. I'm part of the qLegal team, along with this terrific group of students. So in addition to the public legal education workshops like this one, qLegal also runs a legal advice clinic where eligible entrepreneurs can apply and come in and get bespoke legal advice for your business. So it could be some of the questions that you're asking here in the chat. If you're unable to find a satisfactory answer, for example, to the question about sort of the intersection between trademark and company registration of your name, you could come into our clinic and we could give you what we offer is a 45-minute online interview with a team of students and a practicing solicitor from London. And then we take about 3 weeks to do our research and write up a very detailed legal advice letter to you. So if you're interested in that service, please do apply through our website, through the link. We do have an income cutoff for companies. We're giving this, of our services are free, so we have an income eligibility threshold. So you can find those details on our website and then apply.
Excellent, thanks, Eliza. So yeah, please do get in touch with qLegal if you're interested in exploring that service. Again, for further information on that and to sign up to our newsletter to make sure you get that handout, please do contact us at uez@essex.ac.uk. So that just about wraps it up today. So thank you again to the qLegal team. Thank you to Tamara, Bunmi, Hamda and Mariam for a really good presentation. So for more from us and the Space to Grow program, so as I said, we have a series of investment readiness webinars covering topics such as these, legal documents. Our next session is on the 30th, so that's next Tuesday, where it will be a Q&A meeting with the UEZ team to discuss any questions that you may have around getting investment ready and your pitch. So please do join us for that. That'll be a very interactive session. And if you have any questions in advance, please do send them in to us at uez@essex.ac.uk. As I said, all of the videos of our past sessions can be found on our YouTube channel. Thank you everyone for coming, and we hope to see you next time.